case briefs, and so much more. LSData's got what you're looking for.
In an intriguing case heard by the Michigan Supreme Court in 1888, the tension between an individual's right to privacy and the adverse impact of obstructing neighbors' sunlight and airflow was put under legal scrutiny. The contentious lawsuit, Burke v. Smith, drew its roots from a simple but significant neighborhood dispute. The plaintiff, who was a landlord to multiple rental houses, brought forth a complaint against the defendant, their neighbor. The reason behind the court's attention was as striking as it was unusual. The defendant had erected screens that, according to the plaintiff's claim, blocked light and air from reaching the properties, and consequently devalued them significantly. The underlying issue here pointed to a broader legal principle of not causing malicious harm that lessens the value of a neighbor's property. Once this disagreement was brought into the legal arena, the lower court had a delicate task at hand. While recognizing the defendant's right to privacy, the court nevertheless found the screens created a nuisance, a violation of the plaintiff's entitlement to enjoy their land. The plaintiff sought to alleviate this perceived harm through abatement and a perpetual injunction. But as the case was appealed and landed before the Michigan Supreme Court, the final decision would prove to be an unforeseen outcome for the plaintiff. With careful regard for the universal weight of authority and backed by the best legal reasoning, the court ruled in favor of the defendant. The court acknowledged the seductive allure of securing a sweeping view over a neighbor's land, but clearly distinguished it as a mere privilege, not an inalienable right. Every individual's essential right to privacy did not implicitly oblige them to provide their neighbor an unobstructed prospect. As a result, the plaintiff had no genuine ground to object to the defendant's use of their own screens, an act within their property rights aimed at maintaining their own privacy. As the dust settled on this unusual lawsuit, the bill was dismissed with the costs being borne equally by both courts, a final judicial stroke in this intriguing property dispute.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class